the ticket thing, and he was out in the hallway. I had somebody come take
Okay, there we go. All right, so if you all will look up at the monitors, I'm going to go over this very quick PowerPoint. Then we're going to call the calendars, figure out who's here, and then go from there. So as you all will see there, this is the Spalding County State Court. My name is Josh Thacker. I'm your judge, and this is the probation and non-jury calendars. I want to say that here in the Spalding County State Court, we believe that each of you, as you interact with this court, deserve the respect and the dignity that you would wish for someone you care about. We will extend that to each and every one of you as we interact with you all here today. Hey, don't talk during court. Our goal is to move your case forward, return you back to your lives. You cannot do that if you're having sidebar conversations, and you'll find out pretty quick I don't have much patience with that. Nobody is virtual. All right, cell phones. Everybody grab your phone out of your pocket, purse, pouch, wherever you stashed it. Make certain it is off. If it rings after this moment, it means you ignored my request to triple check your phone. And then I have to deal with a contempt hearing. Don't make me do that. Lots of movement out in the gallery. Thank you very much. This is the correct courtroom for you if you're on probation with Spalding County State Court. And you're supervised by the Spalding County Sentence Enforcement Team, or you have some other motion that needs to be heard, or you have, I meant to remove that. All right, this is not the courtroom for you if you received a citation from the City of Griffin Police Department and you were supposed to be next door in the Griffin Municipal Court. Is there anyone here who received a citation from the City of Griffin Municipal Court and you're here for your first court date? All right, great job, bailiffs, as always. Or you're supposed to be in Superior Court or some other court here in the building. All right, so I'm putting up this picture of the Janet Harmon Bragg mural. So just to say why I'm doing this is that I need help, and I need your help. And so here's what that help looks like. So when you signed up for reporting to the Sentence Enforcement Office, you agreed that you would park in the City of Griffin's Janet Harmon Bragg parking lot. And this is the beautiful mural that's painted in her memory. She's the first African-American commercial pilot in the United States, since she was from Griffin. And so I'm sure every one of you all park there every time, but many of my tribe members do not park there. They park in spots that are not even parking spots. They block driveways. They do all kinds of bad stuff that make people mad, which make them call my cell phone on Wednesday afternoons and Thursday afternoons. And I'm tired of getting phone calls of angry business owners in the area. So here's where y'all come in, and here's what I need. When you report next time, you are going to, number one, park in the Janet Harmon Bragg parking lot. You're going to sit in the lobby. You're going to turn to the person on your left, and you're going to go, hey, where'd you park? And then they're going to say, I parked at the post office. And you're going to go, you shouldn't do that. You should go move your car before Judge Thacker issues a warrant for your arrest. And then they say, thank you. And then you'll feel good. And then they'll not go to jail, and everybody wins. And then you're going to do the same thing with the person on your right. So you're going to do that twice every time you report. All right, everybody's nodding at me. All right, I'm officially knighting you as my assistants to get that fixed. It's getting better, but it is not fixed yet. All right. We're about to call the calendar. When you hear your name called, stand up for me. If you're not able to stand up, that's okay. Raise your hand real high. Several of you have attorneys here representing you. Let them announce for you. If you do not have an attorney, then you're going to announce what you are here for. So if you're probation, you just stand up and say probation. And then we'll pivot to the non-jury calendar second. So if everybody will grab the probation calendar, I'd like to call that one first. Okay. So you want that one. All right, you're good to go. All right, you ready, Marty?
Yes, sir.
Okay, so calling the probation calendar is, I show that Darian Adams is not present. Darian Adams? Nope.
That's for probation warrant felony.
Granted. Okay. All right, granted. Destiny Argo. All right, she is here, and we'll come back to that in just a minute. I show Deontay Chile is not here. Deontay Chile?
That's for probation warrant felony.
Granted. All right, Latrevius Collier, perfect. All right, if y'all just announce here or something really loud, we'll be good to go. All right, Janiah Duggar, I showed not here. Duggar? Nope,
Ask for a probation warrant for towing.
granted. Oh, no, it's missing. All right, that warrant's issued. Duggar's probation is told. Moving on to page 2, I show Sandra Evans is here. All right, thank you, Miss Evans. All right, the next several folks are not here. Brittany Green,
That case is off, Judge.
wonderful. All right, Elizabeth Heath,
That case is off, Judge.
excellent. Y'all have had good success. All right, Molly McCullers is not here. McCullers,
Ask for a probation warrant for towing.
granted.
She already has a warrant for new charges.
Perfect, so that will just hold it.
Yes, sir.
Okay. All right, everybody good on page 2? All right, on to page 3. David Nelson,
That case is off, Judge.
excellent. All right, Rainier Pitts. All right, thank you. All right, I show absent Patricia Poole. Poole? No?
Ask for a probation warrant for towing.
Granted. I'm missing a signature.
No, sir, you're not.
No, okay. All right, that's page 4. Everybody good? All right. Page 5, Walker. All right, you're here. Okay. All right, Aaron Wardlow.
I reset that case, Judge.
Oh, okay, great. Reset. All right, Stanley Whitfield. Perfect, thank you. Doyle Williams.
East Present, Your Honor, we have the consent on the probation and the plea on the new charge.
Okay,
So
thank
it's
you.
It's in your basket.
The new charge would be,
25 SR 0894.
that's correct.
25 SR 0894.
894.
Got it,
It's a battery and destruction of a 911 call.
okay. Got it. All right, that's page 6. On to page 7, Sabrina Williams. All right, thank you so much. All right, that's the probation calendar. And let's call, if y'all are good, let's call the non-jury calendar, and then we can start sorting everybody out. Anybody need anything on probation before I move to next?
No.
Okay. All right, on to the non-jury calendar. Frederick Blankenship was here for an ignition interlock device. I spoke with him before court. I sent him back to DDS to get some more information and to come back. If he doesn't make it back by the end of today, I'll deny it, then he can refile. But I think he'll be back. All right, Mark Bruce.
Is here, Your Honor, that was a motion to work his bond, but we enter into a plea agreement.
Okay.
The plea papers are on your desk.
All right, sounds great.
And with a plea, we'll withdraw our motion.
Okay, we'll take that in just a bit. All right, I show Brendan Folsom. Looks like a bond revocation hearing.
It is, Judge, that's the state's motion to revoke bond.
I'm not seeing a response.
We filed it on, file copy seventeenth of April, seventeenth of July. He was served his last note,
Today's the 17th,
oh, I'm sorry, the seventh.
7th.
We filed it on the 7th of July, sorry about that. And I just don't have the stamp copy in front of me. And he was served the same day by mail. We also served his attorney, the Jukes Law Firm. As he's failed to appear, we would ask the bench warrant issue.
All right. As there's no response, I'm going to issue that warrant. Anything, Mr. Charles, you wish to put on the record?
No basis to oppose, Your Honor.
Okay. All right. So I'm going to say issue the warrant. It'll officially be a do not reset. And we'll see him out of the jail at some point. All right. Brian Grady. Grady?
So is that Mr. Singleton's motion to lift the bench warrant?
I seen him this morning at a racetrack. He said he was going to Coweta.
Yeah, I think he's got a conflict in.
All right. Is Mr. Grady here? Okay. That's fine. That's just trying to figure out what the logistics are here. I'm just going to
I
put,
think he'd be here because he's got a warrant.
yeah. All right. That'll work. We'll circle back to it. All right. Sky Hudson, revocation hearing. Hudson? No?
Yes, that's the state's motion to revoke bond. We filed that on July the 7th. Noticed Ms. Hudson by serving her attorney, the Jukes Firm, on the same day. As she's failed to appear today, we'll ask for a bond issue this matter.
All right.
I'm sorry, Your Honor, that's not our case.
She's pro se. Okay. We served her. I don't have the stamp copy in front of me. We served her as a pro se defendant at the address that she gave on her most recent arrest bond.
Okay.
And she was served with statutory notice and plenty of time for today. And as she's failed to appear, we'd ask the bench warrant issue.
All right. That's granted. And no, she's not y'all's public defender. You're good to go. Okay. That's page 2. On to page 3.
There'll be a write-in on page 2 there, Judge.
I'm ready.
It's gonna be the state versus Stephen Kelso.
Okay.
And that's 25 FAH 1235. That's a motion to modify bond. You got a case number?
You put it on the last.
That's
Carly's.
on the last page.
Saying, oh, there it is. Yep. Very last item handwritten in.
Okay, it went on mine. That's a motion to modify bond
From him,
from us.
from y'all. So it's the
It's
state.
25 SR 0988.
25 SR 0988.
Yes, it's
And-
harassing phone calls.
All right. So
There was
it's,
no conditional bond issued. It was granted a OR bond.
okay.
And we're just asking that the bond be amended to that condition. of the
Right.
state limit.
Perfect. And Stephen Kelso present? Here. All right. Thank you. All right. We'll circle back to that. And I assume you'll have a conference with him to
Yes,
see if
right.
those terms are
Yeah.
acceptable? Okay. Mr. Kelso, the state's going to speak with you in just a little bit, explain what they're requesting, and then you'll decide if that's reasonable or if you need the court to make the decision, okay? Yes. All right. All right, then that's page 2. Mervista Larry? I show not present. No response.
That was not ours.
I believe it's a pro se motion to modify probation.
We
Okay,
ask that that motion be denied for lack of prosecution on Mr. Leary's part.
granted. Okay. Alice Newman is here. You're looking for a permit. Okay. Did you give your paperwork to the bailiffs?
I hadn't seen her.
Okay, go give your paperwork to the bailiffs, please. I'll take a look at it.
And I stated before, I'm gonna say it again, the state opposes Ms. Newman driving. She's
I-
not gonna drive a car.
I get it. I just, the last time she was here, I just didn't have enough information to make that decision. Your objection is well known, because again, I'm very familiar with the history of this case. So. Okay. All right. Everybody's here for this page. Dylan Parker. All right, he's here.
Morning, Your Honor, James Dutton. This is a motion to terminate non-reporting probation.
Okay. All right, motion to terminate.
I would
All
like
right.
to speak to Mr. Dutton in a minute.
All right, that sounds great. Carleon Rideout?
Here,
All right, and
pronounce Carly.
Carleon? Names are, Carlene. Names are important, and I will get it right moving forward. Carlene.
I believe that's her motion.
All right, and you filed this motion for this morning?
You talking about?
Yes, ma'am.
I did it, last week sometime.
Okay.
I'm not sure of the date.
All right, that's okay. We'll circle back to it. Thank you so much. And Rideout is your last name?
Yes.
Okay. Got it. Thank you. All right, Christian Rodriguez Menez. I have him marked here. No response?
I think she was one of the ones you sent to the DDS.
Yes.
Oh, that was that lady. Yes. Okay. She was here for an ignition interlock device. I sent her back to DDS. She's supposed to come back with a new report, hopefully this morning. If she's not here by close of court, I will deny it with leave to refile. Ashley Thompson.
Your Honor, she's here.
Okay.
That was a motion to vote bond.
Okay.
But we resolved the case, so the motion will be moved.
Okay.
The papers are on your desk.
All right. Perfect. All right.
We'll withdraw our motion.
All right, perfect. Selwyn Tolbert was an ignition interlock device request, same instructions, sent him back to DDS. He said he did not believe he would be back today. I told him that no problem, I would deny it with leave to refile. All right, Aaron Watson. All right, thank you, Mr. Watson. Let's see, there's a motion to modify. Got it. All right, Gregory Weinstein.
That's
Okay.
Mr. Sellers' motion to modify bond.
Okay. All right,
I
we'll
think
see.
Mr. Sellers has a conflict in it, but she does. yeah.
That's fine. We'll see him when he gets here. If you want to, Mr. Sellers has a valid, that was you again. Okay, Mr. Sellers has a conflict in. If you want to check in with his office and just kind of see what an estimated time of arrival would be, that'd be great. But other than that, we'll just wait until he gets here. So if you want to call his office, great. If you just want to wait till he gets here, that's fine as well. All right, I show this one is absent. Amos Williams?
Sorry.
Amos Williams? Oh, Amos Williams, yeah. All right, no response.
That's the motion to vote bond, Your Honor.
That's-
You want to notify by our office.
Okay,
Yeah, we filed this on July the 7th of 2025. Served his attorney, the Dukes firm, on the same day by mail and also by hand delivery. As he's failed to appear, we'll ask for a bench warrant issue this matter.
all right, that's granted. And then the handwritten Stephen Kelso. Okay, is there anyone out in the gallery whose name was not called? If so, stand up for me. Anyone in the gallery whose name was not called? All right, so far so good. You want to do some conference? Do you have conferences on this? Okay, all right, so what we're going to do next is, it's 9:41, we've called the calendar, we've identified everybody out there. What we're going to do is, we're actually going to do kind of a little rapid set of conferences. So what's going to happen is, Director Matthews here, do you have anybody with your team here?
Not yet, they'll be
Okay,
over shortly.
they'll be here. So Director Matthews or one of her team members, for those of you on the probation calendar, will very likely call your name. They will have a very quick conversation with you where they will present to you the state's offer to resolve your probation matter today. It is not a negotiation. It is just an up or down, yes or no. You either accept what's being offered, at which point you'll be allowed to sign it and you'll be free to go. Or you say no, thank you, which is perfectly fine, at which point you grab a seat and then we'll have the hearing with me later. I have no preference on that. I just want to make certain it's very clear that that is not a negotiation. It's just to take it or leave it, so that, because we've got to have the hearings. Mr. Shepard at the same time will be, and Ms. Sexton will be speaking with those that are on the non-jury calendar to try to resolve those cases as well. When I come back out, my plan is to try to knock out the probation calendar first with whatever's left. Hopefully while y'all are finishing up the non-jury conferences. If somebody feels very strongly differently, let me know. While we're there, I will say that Mr. Blankenship has returned with a new printout. I'm gonna take a look at that back in chambers. All right, anything, do you need anything else?
No, sir.
Ms. Shepard?
No.
I just have three, please, Your Honor.
Okay, all right, perfect. So I've got, do what?
Ms. Newman had to go back down to
That's fine. That's our third trip to DDS on this case.
Hope she's not driving.
Okay, so that's fine. Let's do this. Why don't I just come back out? Well, are y'all saying that these are ready?
That's all he has left.
That's all you have? I just heard that, so.
You're ready.
I can
well,
get moving on some stuff while you take those, please.
You okay? Is that gonna mess you up anyway?
I'll get Mr. Charles out of here.
Yes, thank you.
Okay, well then I'm gonna do these three, please. Get Mr. Charles out of here. That'll also finish up the jail case. That's why I was keep circling back to it.
Can we do the jail case first,
Yes.
Your Honor, so they can, Mr.
Yeah, come on around.
I don't think I need that.
I'm just gonna do these three, please, and then we'll go.
Right here.
All right, are you Doyle Williams?
Yes.
All right, Mr. Williams, I'm gonna place you under oath. Are you ready?
Yeah.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, take your hand down, state your full name for me.
Joel Martin Williams.
Mr. Williams, you are here on a couple of matters today. You're on 24 SR 0324, 24 SR 0325. These are probation matters. And then we have a new case that you're going to enter a plea to today, which is 25 SR 0894. Is that your understanding of what we're about to do?
Yes.
All right. Now, on the two probation matters, you have presented to me through your attorney two consent orders that revoke, it looks like a substantial amount of time on these cases and move them towards closure. Is that correct?
Yes, Your Honor, the total gonna be 12 months to serve on all three cases
And be done.
and be done with it.
Is that correct?
Yes,
Is that what you want to do?
yes,
So you want me to sign these consent orders and close these cases?
yes.
All right, I'm doing that right now. All right, those two cases, which are 24 SR 0324 and 0325 are closed. Do you want these to go?
Yes, sir.
Okay. All right, I've passed those down to sentence enforcement. Mr. Dole, we're going to enter this plea now on 25 SR 0894. I'm holding up this attorney and defendant plea rights waiver. Do you recognize this document?
Yes,
And are these your initials next to each of the lines on page 1?
yes,
Page 2?
yes,
Is that your signature?
yes,
Did you sign and initial this document after having all the time that you needed to review it?
yes,
And did you have a chance to ask your attorney, Mr. Charles, any questions that you had?
yes,
Did you understand everything on this document?
yes,
Are there any questions I can answer for you about anything anywhere on this document?
no,
Mr. Williams, have you had all the time that you need to speak with your attorney about all aspects of your case?
yes,
Of your cases, excuse me. Are you satisfied with the job your attorney's done on your behalf?
yes,
Do you understand that you have the right to a jury trial?
yes,
And that by entering this plea, there will be no trial and this case will be closed? Is that what you want to do?
yes,
Mr. Charles, do you stipulate that there is a factual basis to support count 1 battery from 5/25/25 here in Spalding County?
Yes, I do, Your Honor.
Do you wish to enter a guilty plea to that battery charge?
yes,
Mr. Charles, do you stipulate that there's factual basis to support the obstructing of a 911 call charge from the same events?
Yes, I do, Your Honor.
Do you wish to enter a guilty plea to count 2, obstructing a 911 call?
yes,
I find between Mr. Charles' stipulations and Mr. Williams' request to enter a guilty plea that there's enough for me to take his plea. I find that he's knowingly, voluntarily, and intelligently waiving his rights in entering this plea. I've reviewed the recommendation and I'll follow it. Anything you wish to add?
No, sir, thank you very much.
Any questions, Mr. Williams? The sentence of the court is on count 1, battery, guilty, 12 months to serve. Count 2, obstruction, 911 call, guilty, 12 months to serve. Concurrent for a total of 12 months to serve. And I believe that runs concurrent
With the probation.
with the probation revocation. Okay. Then you have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas right. Mr. Charles, I'm just going to have you sign on the witness line, and as soon as you do that, y'all can take that apart and give him his copies. All right, Mr. Williams, you may go back to the jury box. We're finished with him. As soon as he gets his paperwork, he's free to go. Or y'all are free to go to take it. He's not free to go.
Thank you, Judge.
Okay. All right, this looks great. Okay, so you can take those apart, and he gets a copy to take back. And then Harry gets a copy, and then the originals go to Carl. All right, Thompson. All right, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down. Use the microphone and state your name for me.
Ashley Thompson.
Ms. Thompson, you were here, I believe, on the non-jury calendar. There we are, bottom of page 4. For the state's motion to revoke your bond, it looks to me like y'all have reached a negotiated plea. Is that correct?
Yes, sir.
All right, if you, on 23 SR 1695, 24 SR 1423, and 25 SR 786. So one case on the calendar, but there's multiple cases on that are outstanding. Okay, so your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document?
Yes, sir.
Are these your initials next to each of the lines on page
Correct.
1?
Yes, sir.
Page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
Did you have an opportunity to ask your attorney any questions that you had?
I did. Yes, sir.
And did you understand everything that's on it?
Yes, sir.
All right. Have you had all the time that you need to speak with your attorney about all aspects of your cases?
Yeah, yes, sir.
Are you satisfied with the job Mr. Charles has done on your behalf?
Yes, sir.
Do you understand you have the right to a jury trial on each of your cases?
Yes, sir.
And that by entering this plea, there will be no trials and all of your cases will be closed. Is that what you want to do?
Yes, sir.
Okay. Now, you have 3 cases. Let's see. Looks like our sentencing order is going to be 23 SR 1695, and then 24 SR 1423, and then 25 SR 786. So starting with, that's all right, Kathy. Kathy's having trouble. All right, so starting with 23 SR 1695, Mr. Charles, do you stipulate that there's a factual basis for count 1, the criminal trespass charge from 10/27/22 here in Spalding County?
Yes, I do, Your Honor.
Ma'am, do you wish to enter a guilty plea to that criminal trespass charge?
Yes, sir.
All right, moving on to your next case, which is 24 SR 1423. This is a family violence charge. Do you remember reading, ma'am, on the back of the right sheet and pivoting back to the attorney and defendant plea rights waiver, that any family violence conviction will cause you to lose your firearm and ammunition possession rights?
Yes, sir.
All right, and the reason I'm bringing that back to you is that you mistakenly initialed that you're not pleading to a family violence charge, which is partially true because 2 of your 3 cases are not family violence, but this middle one is. Do you understand that?
Yes, sir.
All right, so is it acceptable to you that I mark out that line that says I'm not pleading to family violence and initial it?
Yes, sir.
All right, and John, if you'll have her initial next to my initials.
Next to it.
Okay. All right, so, all right, this looks good. Mr. Charles, do you stipulate there's factual basis to support this battery under the Family Violence Act charge from 8/18/24 here in Spalding County?
Yes, I do, Your Honor.
And Ms. Thompson, do you wish to enter a guilty plea to that
Yes,
charge?
sir.
All right, last case, 25 SR 0786. Mr. Charles, do you stipulate that there's a factual basis to support this criminal trespass charge from 5/17/25 here in Spalding County?
Yes, I do, Your Honor.
All right. Ms. Thompson, do you wish to enter a guilty plea to that charge?
Yes, sir.
Okay. I find that between Mr. Charles's stipulations as to the factual basis, combined with Ms. Thompson's request to enter guilty pleas across all 3 of her cases, that there is enough for me to take these pleas. I find that she is knowingly, voluntarily, and intelligently waiving her rights and entering these pleas. I've reviewed the recommendations and I will follow them. Mr. Charles, anything you wish to add?
No, sir, that's it. Thank you, Your Honor.
All right, Ms. Thompson, any questions before I sentence?
No, sir.
Okay. Ms. Thompson, on 23 SR 1695, count 1, criminal trespass, guilty, 12 months, 590 is your fine. That's a total of 12 months probation, 30 days to serve. Has she served that or she needs to serve
No,
that?
she need to serve that. Your
Okay. Are you serving that in one 30-day block, Ms. Thompson?
I'm not for sure. He said that it would be discussed with the probation.
Okay, then I'm just gonna place that you must, that on that, you must, work that out, and you will begin it within 30 days, from today.
Yes, sir.
All right, I've got that covered. All right, so, so 590, you may work your fine off with community service work. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver, $60 per month supervision fee, $50 intake fee. This is consecutive to any other sentence to this court. $100 in restitution to Spalding County to offset the cost of your attorney. Your jail time will begin within 30 days as directed by sentence enforcement. You'll complete 20 hours of community service work. You'll have no contact whatsoever with Donald Taylor or any Walmart.
Yes, sir.
Okay. Ms. Thompson, moving on to 24 SR 1423, count 1, battery under the Family Violence Act. Guilty, 12 months, 590 is your fine. Same standard conditions, including the restitution to public defender. Same no contact provisions. And this is consecutive to 23 SR 1695. Any questions so far?
No, sir.
All right, last case. 25 SR 786, count 1, criminal trespass, guilty, 12 months, 590 is your fine. All other conditions are the same as the previous cases, except this is consecutive to 24 SR 1423. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you wish to use your habeas rights. Any questions before we part ways?
No, sir.
All right. I do need to gently but firmly point out to you that I can see your belly button, and that is unacceptable for a courtroom. And you need to make certain that when you report to sentence enforcement, that you dress appropriately, because that will be a violation of your probation. Do you understand that?
Yes, sir.
And if you ever step foot in this courtroom again, I'm going to expect that you're dressed appropriately, okay? I mean, I guess the easiest way to say it is, no one wants to see my belly button, and I don't want to see yours. Fair enough?
Yes, sir.
Okay. All right, you remember that, all right? Thank you very much. All right, last case, Bruce. All right. All right, Mr. Bruce.
Yes, sir.
All right, Mr. Bruce, if you'll please step into that microphone, raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, take your hand down and state your full name for me.
Mark Anthony Bruce.
All right, Mr. Bruce, you have two cases on the calendar today, 24 SR 1497 and 25 SR 0146. Mr. Bruce, we're going to start with this attorney and defendant plea rights waiver. Do you recognize this document I'm holding up?
Yes.
Are those your initials next to each of the lines
Yes.
on page 1?
Yes.
Page 2?
Yes.
Is that your signature?
Yes.
Did you sign and initial this document after having all the time that you needed to review it?
Yes.
Did you understand everything that's on it?
Yes.
Are there any questions I can answer for you about anything on this document?
No.
Okay. Have you, did you have an opportunity to ask Mr. Charles, your attorney, any questions that you had about this document?
Yes.
Have you had all the time that you need to speak with Mr. Charles about all aspects of both of your cases?
Yes.
Are you satisfied with the job Mr. Charles has done on your behalf?
Yes.
Do you understand that you have the right to a jury trial on both of your cases?
Yes.
That by entering this plea, there will be no trials and both of these cases will be closed. Is that what you want to do?
Yes.
All right. Do you have any questions for me before I talk to Mr. Charles?
Yes, I'd like to, of course, to know that I'm a caretaker.
Yes.
For my mother. And
Yeah, this is just about the rights and stuff.
Okay.
We're going to get to that.
All right.
So you're going to get to do that. All right, Mr. Charles, do you stipulate that are these concurrent?
no, they are consecutive.
Consecutive.
You got the DUI, because he had so much to do on the DUI, we're gonna put the criminal trespass following the DUI.
All right, come here just real quick. There's just it's written up both ways. So up here, so it seems like, but then down here, Patrick Gray.
Oh, okay.
So
That is his choice.
it's a gift for you. So.
Yeah, it's a gift for him, but he gave him 24 months, so he didn't see that.
Okay, so
Right.
Patrick's changed it to.
He changed it to 24 months instead of,
That's
it's
fine.
still going to be 24 months.
Yes.
So give him 24
All right,
months.
I just want to make certain that,
Yeah,
Okay.
we do not do probation of one,
all right,
for only DUI.
this makes sense. All right, so Mr. Shepherd, who's out having conferences right now, granted one of Mr. Charles's requests on this, but we didn't quite get that communicated, so we've got it right, and it's in your favor. It's in your benefit.
Okay.
So, all right, so Mr. Charles, back at this, do you stipulate there's a factual basis to support the criminal trespass charge from 12/31/24 here in Spalding County?
Yes, I do, Your Honor.
Mr. Bruce, do you wish to enter a guilty plea to that criminal trespass charge?
Yes.
Moving on to 24 SR 1497. Mr. Charles, do you stipulate that there's a factual basis to support count one, the DUI charge from 7/23/24 here in Spalding County?
Yes, I do, Your Honor.
Do you wish to enter a guilty plea, sir, to that DUI charge?
Yes.
And then lastly, the stop sign violation. Mr. Charles, do you stipulate the factual basis for that charge?
Yes, sir, I do.
And Mr. Bruce, do you wish to enter a guilty plea to that stop sign violation from the DUI charge?
Yes.
All right, then I'm gonna find between Mr. Charles's stipulations as to the factual basis combined with Mr. Bruce's request to enter guilty pleas, that there's enough for me to take these pleas. I find that Mr. Bruce is knowingly, voluntarily, and intelligently waiving his rights and entering this plea. I reviewed the recommendation and I will follow it. Mr. Charles, anything you wish to add?
Yes, Your Honor, as he was saying, he has to serve 30 days by law because this is his fifth DUI. He's the caretaker for his mother, and he was asking the court to be lenient on that. But I told him that's something that you can address and within your province to do what you can for him, if anything is possible. But the statute said 30 days.
Yes, I agree with that. So, Mr. Bruce, would weekends give you a sufficient amount of time to step away from your caretaking responsibilities? I don't know. We're having trouble with the weekends.
So they're not doing weekends.
So,
Weekends equals no go.
I know. Is there,
He was saying that if he can be, I don't know if the court ever used that. He said if he can be on Hasselway.
I tell you what I'll do. I'm not gonna order anything at this point. I'm gonna let Director Matthews and her amazing team try to come up with a solution. Sorry, I'm passing this to you. I know, I saw that. It was a fair look too, by the way. So I'm gonna let them try to come up with a solution.
And let us do that, right?
And whatever solution they come up with, I'll very likely approve. So, and that way we'll go from there. Okay?
Okay.
All right. Anything else before I sentence?
No, sir, thank you very much. Not for me.
Okay, anything else? Sorry, you're good, Ms. Shepherd. All right, so on Mr. Bruce's first case, 25 SR 0146, count one, criminal trespass. I find you guilty. It's 30 days to serve. And it's all concurrent, so I'm actually gonna, to simplify this, I'm actually gonna initial time served on this one, so the jail doesn't get mixed up and have him do 60 days. All right, so that closes out 25 SR 0146. Moving on to the big case, the probation case with DUI. Count one DUI, guilty, 12 months, 2091 is your fine. Count four, stop sign violation, guilty, 12 months consecutive, 158. Count three is dismissed. Count two merges into count one. 24 total months of probation, 30 days to serve. You work that out with sentence enforcement. No alcohol, illegal drugs, or hemp products should be tested for those. Fourth Amendment waiver. $60 per month supervision fee, $50 intake fee, $100 in restitution to Spalding County to offset the cost of your attorney. Your jail time will be served to begin within 30 days as directed by sentence enforcement. And I'll give them wide latitude in coming up with a solution. 240 hours of community service work at no less than 6 hours per week. Substance abuse evaluation, DUI school within 60 days, and you must get your license back. You have 30 days from today if you wish to appeal this decision. You have 6 months from today if you wish to use your habeas rights. Anything else on this matter before I close this plea out?
No, sir.
Okay, any questions, sir?
Just me, being able to stay home and take care of mom, no.
Okay, and I don't have that answer. You're gonna need to work that out with sentence enforcement. All right, Miss Margaret's gonna walk out those double doors to check off the last of your paperwork. Good luck to you, sir.
Thank you.
Anything else? Let's run through the calendars just real quick, then work our way through the probation matter, and then deal with whatever else is left. So if everybody will grab your probation calendars, we'll just run through it real quick, see what's going on, and go from there. Ready? Actually, let me go ahead and swear you in. So, yeah, Director Matthews, do you solemnly swear or affirm that all testimony you'll give in all matters today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you're sworn on all testimony. All right, so Adams is a warrant. Argo,
That is a consent, Judge.
okay. Okay. You need me to sign these here too?
Yes, Sam, those were the warrants we didn't have prepared earlier.
I may have missed a signature on the first one.
You did not.
Okay. All right, Argo is a consent. Chile is a warrant. Collier,
That's gonna be a hearing, Judge.
okay, sounds good. Duggar is a warrant. Evans,
That is a consent.
excellent. Looks great. All right, Green is off. Heath is off. Colors is a warrant. Nelson is off. Pitts,
Consent.
excellent. All right, bless you. All right, Pool is a warrant. Walker,
Consent.
wise choice. I was waiting for that one.
Yeah, I was gonna have a few things to say about that one.
Yeah, very wise choice. He did not want to see me. Okay. Warlow is reset. Whitfield?
Consent.
Okay. And then Williams was consent. We did that before the break. And then Williams.
That's gonna be a hearing, Judge.
Great. Okay. All right, so 2 hearings is what I'm showing left?
And no consents were offered on both of those
Oh,
hearings.
that makes perfect sense. Okay, then let's call the non-jury calendar. Mr. Blankenship came back with his paperwork. It looks great. I just don't have Angel here to do the order, so just be patient with me. Thank you, sir. My staff went on vacation because apparently they're allowed to do that every now and then. So, so just be patient with me, okay? All right, Bruce,
That pled.
that pled, yeah, I was about to say, I thought I took that pled. Okay, Folsom was a warrant. Grady, did Mr. Singleton get here? All right, we're still waiting. All right, that's page 1.
I've heard your name, Mr. Singleton, on that.
Okay,
And it's an active bench warrant for the second case, so it's a,
is this one an active bench warrant?
yes.
Okay.
Sir. It's,
Well, that makes sense of why he didn't send his client ahead.
Yeah, that-
So, because I would have no choice but to take him into custody, so.
And like I said, I talked to him for about 5 minutes at racetrack this morning and asked him where he was going today, and he said he was headed off to Coweta County, so.
This all makes sense. He's just trying to walk in with his client so that hopefully he can walk out with his client. I get that. Okay, we may just end up moving this, Harley, to just a date of your choosing. All right, Hudson is a warrant. Larry is a defense motion. I'm going to deny it for lack of prosecution. Newman? Okay, I heard she went again to DDS. I don't know. Okay,
Yeah, I saw her earlier.
Yeah, Mr. James, told her, she brought back her, what's
the suspension detail report.
that, and, he told her what she needed to go do. She had to go back and, take some kind of test or something.
Yes.
So he said that you would not see her until that was accomplished and it was
Yeah.
ready.
That's exactly what I thought it was going to, that's what I anticipated it saying, so. All right, well then that's all for today. I'm gonna actually, because she's gonna have to go do that test. I'm gonna issue an order denying it. She can refile once she gets the class taken. And again, I don't even know if I'm gonna grant it. These are just the things I'm requiring before I'll even consider it. So she may get to the end of this and not get it, and she knows that because I said it last time she was here. So, all right, then that's Parker.
That was a consent,
All
Judge.
right, consent.
I've got to prepare an order for you on that, Judge. I'll
Okay.
get that done later today or tomorrow.
That sounds great. All right, write out.
Yes.
That's a pro se modification to terminate probation.
Okay, all right, we'll come back to you. Rodriguez Menez, did she come back? Okay, then that's denied for now. She can refile. That was for ignition or lock device. Thompson, she pled. Colbert, that's denied for now. He can leave, he can refile. Aaron Watson,
He has a defendant's motion.
okay, perfect. Weinstein, that's Mr. Sellers.
That's correct, Judge, and we have a consent in that case.
Okay. Do y'all have it ready for me to sign or just want to
I
present
do,
it?
Judge. Thank you, Your Honor.
This is the only thing you have, right?
That's correct, Judge.
All right.
And as part of the case, Judge, we've also filed an affidavit from the victim in support of that, and it's part of the case file.
Okay, thank you for that.
Thank you, Judge.
Looks great.
That's all I have, Mr. Chief.
Yes.
Thank you, Judge. See you. What'd you do? Surgeries. Gotta have them next week. Can't move them over.
Well, if we can help you at all, let us know.
Thank you, Judge.
You're right back here.
Depends on your teeth.
All right, Williams is a warrant, and then Kelso was that consent bond I signed back in Chambers, is that
Yeah,
right?
that's correct.
Okay. Well, then, if it's all the same, I'd like to jump into, if anybody has any different requests, that's fine, but otherwise I'm gonna jump into probation matters. So that would be, can I please have, Collier, I believe? Come on up. All right, Mr. Collier, if you'll come on up to the podium and raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down, state your full name for me.
Lee Travius Collier.
All right, I think his mic might be off. I'm not seeing a light, and he's not very loud. Perfect. All right, let's try that again. State your name again.
Lee Travius Collier.
Now we're good. Okay, so, Mr. Collier, you are here today on 23 SR 0549, and you're here today because your sentence enforcement supervisor has filed paperwork with the court alleging that you're out of compliance with your probation.
Yes,
You
sir.
understand what you're doing here today?
Yes, sir.
You have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do?
Yes, sir.
You ready to go forward?
Yes, sir.
Okay. Then what we're going to do is I'm going to have Director Matthews read out. Do you have a recommendation at all?
Yes.
Okay, so I'm going to have Director Matthews read out two bits of information. The first is what the allegations are as to how you might or might not have violated your probation.
Yes, sir.
And then she's going to read out what the state's recommendation is on your case.
Yes, sir.
And then I'll ask you two questions.
Okay.
Do you admit to the allegations?
Yes, sir.
Yes or no? And then is that recommendation acceptable? Yes or no? And if it's yes and yes, I'll very likely adopt the recommendation and make it the order of the court, and we'll be done. If it's no, that's perfectly fine. We'll dig in and figure it out, okay?
Yes, sir. Yes, sir.
All right, go ahead.
Judge, on 23 SR 0549, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendant failed to pay the court fines as fees as ordered or utilize community service work in lieu of the court fine, being in arrears $521.30. Judge, this case has limited time. It only has 69 days remaining. We're recommending that Mr. Collier serve 30 days and terminate the balance. He's not willing to accept community service. He's denied that often in the office. I have another recommendation that requires community service if the court wants to hear it, or
I don't have any interest in hearing, but he may. So, all right, do you admit to the violation?
On the, not being able to pay the money?
Yes.
Yes, sir.
Okay. And, are the 30 days acceptable to you, or you want to explore some other option?
Yeah, no, sir, I want to explore some other options.
All right, what's your second option?
my second option is to convert the fine to 75 hours, for him to do 15 hours per week, make a payment of $60 per week, revoke the case in full, and suspend it upon the compliance of the order.
All right, so that's your second option, which is you dig in really hard and try to get it back on track.
Yes, sir.
What do you want to do?
The community service.
All right, well, that's it then. You understand that if you don't do this exactly the way, you've left me no time left. So
Yes,
if you
sir.
don't do it exactly the way you're supposed to, I'm gonna issue a warrant first and we're gonna figure it out second.
Yeah. She explain it to me again exactly?
We're not gonna do it here.
Okay,
She said
all
they've
right.
already reviewed it with you a couple of times though, about converting your fine to community service work, and you declined those each time, so.
Yes, sir.
I'm just gonna let y'all do that back in the office, but I'm just gonna point out that, I mean, is that correct that they talked to you about this a couple of times already? About converting your fines and fees to community service work?
Yeah, yes, sir.
Okay. All right. Well, then I just need you to know that because I have so little time, I have so little options. And frankly, if you had left it up to me, I would have just done the 30 days and closed the case. So you did wise picking that option for yourself
Yes, sir.
instead of letting me pick.
Yes,
So
sir.
if you had said, Judge Thacker, you can just pick whatever you want, I would have picked the 30 days.
Yes, sir.
Because that's the cleaner, easier way to do this.
Mhm.
Okay. All right. You may step over. Actually, if you'll step out in the hallway, have a seat on the bench. You got to go that
Judge,
way.
hold on 1 second. Judge, I'm gonna have him report today between 1 and 5. That way we can go ahead and get him that information and get that community service started.
All right. So you're going to report today to probation?
Yes, sir.
Okay. All right. Miss Margaret's going to walk you out and get you to sign the paperwork. Okay.
Sabrina Williams.
All right, Ms. Williams, if you'll raise your right hand for me.
Yes, sir.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down, state your full name for me.
Sabrina Williams.
All right, Ms. Williams, you're here on 22 SR 1538, and according to, okay, so you're here today because your sentence enforcement supervisor has filed paperwork with the court alleging that you're out of compliance with your probation. Do you understand what you're doing here today?
Yes, sir.
And that you are here today and you have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do?
Yes, sir.
You ready to go forward?
Yes, sir.
All right, so same thing. She's going to read. You have a recommendation?
I do not, Judge.
Okay, so she'll read one thing out, which is the allegations, and then we'll figure out what to do with it next.
Okay.
All right, go ahead.
Judge, on 22 SR 1538, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendant failed to report to probation as directed, having missed 2 of 7 scheduled appointments. The defendant failed to pay the court fees as ordered or request a waiver, being in arrears $150. The defendant failed to complete the fine conversion community service hours as directed. Judge, I do request if you allow Ms. Williams to remain on probation, that you order her to not to be able to call our office by phone. She must communicate by email.
Okay. So how much time do I have left?
She has 197 days.
Okay. Ms. Williams, do you admit the allegations?
Yes, sir. I understand them.
No, do you admit them, or deny them? You can admit or deny.
I'm denying them.
Okay, that's fine. So grab that seat right there, please.
Okay.
So this is officially a contested hearing, and then I'm going to make a final decision as to what I believe is appropriate from the court. Are there any other consecutive cases after this one?
No, sir.
Was the consecutive case.
This was the consecutive case? Okay.
The court has also modified this case on the previous case. The court took away one of the court fines on this case in an attempt to assist Ms. Williams. She had a modification hearing before you on November the 2nd of 2024, where she wanted to move out of the state. And so y'all reduced one of the fines on this case by $303 to try to help speed that process up.
Okay.
Excuse me, Your Honor.
Okay, hold on. This is not my first rodeo, so grab a seat, sit quietly, and let me do what I get paid to do. Otherwise, what am I here for? Okay. So what's going to happen next, ma'am, is Director Matthews is going to say a bunch of things, and then you're going to get a chance to ask her questions. Now, do you have any questions on the procedure we're about to follow? That Director Matthews is going to testify, and then you may ask her questions to clarify anything you think needs to be clarified. And Mr. Shepherd, are you going to be asking questions?
I will, sure.
Okay. All right. So, Mr. Shepherd, you may ask questions.
We already sworn Ms. Matthews in?
Yes.
Okay. All right, can you state your name, please?
Marty Matthews.
And Ms. Matthews, how are you employed?
I'm the Director of Spalding County Sentence Enforcement.
All right, and are you one of the probation officers for Sabrina Williams?
Yes, sir.
And that Ms. Williams at the defense table here?
Yes, sir.
All right, and when was she placed on probation?
This case was sentenced on January 31st of 2024. It was consecutive to 22 SR 1537.
Okay, so 22 SR 1537, is that closed?
Yes.
All right, and when was it closed?
That case, bear with me. It closed unsuccessfully January 30th of 2025.
Unsuccessfully?
That is correct, yes, sir.
Okay.
So, and why was it closed unsuccessfully?
We tried working with Ms. Williams to resolve the court fines on that case, and the case expired before we were able to get those fines collected for the court.
Okay, and what was the balance that was owed when it was closed?
Bear with me.
It's $307.35. Sound about correct?
I know it wasn't a lot. I'm trying to pull it. It's
Sorry,
coming up
I'll
right now.
flat foot it on that.
Yes, 307 and 35 cents.
And so then this consecutive case began when?
January 30th of 2025.
Now, on this case, you filed a petition for revocation.
Yes, sir.
And what grounds?
She's missed 2 appointments. She's behind on her fees, and she hasn't completed the conversion hours as directed. This case qualifies as a warrant, but under Judge Thacker's direction of 3 violations or more. Ms. Rich has definitely worked really hard trying not to do a warrant on Ms. Williams. Against my objection, Ms. Rich set a walk-in hearing for Ms. Williams trying to work with her.
So on the reporting, you said that she's missed 2 appointments?
Yes, sir.
Out of how many scheduled?
7.
Do you know the dates that she missed?
February 13th of 2025, that one was a phone report, and March 27th of 2025, that was an in-person.
And you also allege that she's in arrears?
Yes, in
How
her
much is she in
probation.
arrears?
$150 as of the date the petition was drafted.
And the third allegation is that she has not completed her community service. Is that correct?
That's correct, yes, sir.
Now, did she request to convert her fines to community service?
Yes, sir.
When did she do that?
We converted those on April 21st of 2025.
And did Ms. Williams sign off on that order to modify probation to convert it to community service hours?
Yes, sir.
How many hours has she completed of that?
She's now completed 70 of the 139.
And how many days does she have left?
She has 197.
All right, that's all the questions I have for Ms. Matthews.
All right. Ms. Williams, you may ask Director Matthews any questions that you believe are helpful. You're welcome to use the podium. Just make sure to use the microphone.
Yes,
and
sir.
be nice and good and slow so that Ms. Kathy can record our conversation and have
Okay.
it be clear.
Okay. When I started with the probation, is this pertaining to Miss Rich? Because I never spoke with Miss Matthews. I've only conversated with Miss Rich. When it came to me paying my fines, I had a conversation with you, like on some of my report dates. Well, I'm gonna back up. You had me come in.
Wait, are you talking to Ms. Rich?
Yeah, because I never spoke with her.
Okay, well then, Ms. Rich is not here as a
So
witness.
just-
Director Matthews is the witness on the stand. So
Okay, I'm sorry.
Ms. Rich is just a spectator like these folks out in the gallery.
Okay, gotcha. So Miss Matthews, at the time when I spoke with Miss Rich about helping me with the fine, what can I do? I did complete 20 hours of community service that she had me complete. I did do that. And then, so we came up with a suggestion, like I was telling her, explaining to her that
If Ms.
I was
Williams
having,
wants to testify, she can certainly do that in a few minutes, but I think she needs to ask questions to Ms. Matthews right now.
Okay, so Ms. Williams, take a deep breath.
okay,
And remember that what you're doing right now is asking
Okay.
questions, not
Only,
making
okay.
statements.
did I not ask Miss Rich for help with, paying my fine? And that's when you guys suggested that I take the second opportunity.
It's a standard procedure for the office, if anyone's experienced financial hardship, that they can always accept community service in lieu of their court fine.
Okay, so once I completed it, I was told that it would be half of the balance that was remaining, right? For the fine, if I completed it,
Completed what?
the courses.
The second opportunity
Yes, ma'am.
courses, those are worth 70 hours or $700 off the court fine.
Right, so once I completed it, I didn't get that credit. I only got 300.
I disagree with that. At this point, there's been no credit subtracted from the court fine because you and Ms. Rich recently had a conversation where she advised you the suspension of the court fine will not be completed until all community service conversion hours are completed. We don't do multiple conversions because the clerk's office can't handle multiple orders to suspend money.
Okay, so when you say that, you're saying that the second opportunity, right, that I completed wasn't the whole course that I was supposed to complete for the community service?
Second opportunity is one opportunity for community service that we have in the office. You have 139 hours of converted hours to complete. The second opportunity maxes out at 70 hours.
Okay, so I didn't complete it, that's what you're saying?
You've completed the second
Okay.
opportunity for 70 hours of community service.
Okay, so I wasn't told that it would be, community service that I would have to do, meaning like, the Salvation Army to complete. It was just stated to me that,
If you accepted 139 hours and we've told you that second opportunities were 70, I would think that you would understand that there would be a remaining hours that you would have to complete in another manner.
okay, so that's another reason why I was calling in to get, more information on what you're breaking it down to me as, and me saying that I have questions. You all are telling me now that not to call, just
That
to
is
email.
correct.
Right.
That's
Okay,
correct.
so then, I did complete the last 10 hours that she had said that I need to complete. I have the paperwork. So you're saying that I did not complete it, which I did. I only owe 30 minutes. So I can't do 30 minutes. I have to do 4 hours.
I don't know what you're
So
referencing right this moment.
The 10 hours that she was saying that I needed to complete by court, I completed it. You guys were saying that I didn't complete it.
Did you turn it in?
This would be the day to do it, right? I mean,
I can't testify to stuff that
Okay,
hasn't been turned
okay.
in. I reviewed the case with Ms. Rich on Friday.
Okay, that's all, Your Honor.
All right, thank you very much. You may have a seat. Mr. Shepherd?
Just one question. Ms. Matthews, why is it you're asking the court that she not be allowed to call your office?
Because when she calls my office, one, none of my staff wants to speak with Ms. Williams. She's so nasty to all of them. And she repeatedly speaks in circles, kind of like what y'all just experienced there, where she tries to manipulate the conversation. And Ms. Rich has struggled so much with the communication. She wants to communicate with her only by email, so that way there's a clear record of what was discussed to protect Ms. Rich.
Thank you.
All right, would you like to ask any questions about that statement that was just made?
Yes.
All right.
If I'm calling into the office just because I have a sense of humor and I understand that I'm on probation, I have to make the best out of it. So I'd rather for me to laugh and that person that's on the phone to laugh. I've never called being nasty. I might have a realistic conversation with Miss Rich at once upon a time with me trying to get some understanding about it, because like I stated before, like it's been a while since I've been on probation. But how could you all say that I'm having an attitude with you all? How and what way?
Because often when they try to explain things to you or answer the questions, you talk over them and argue with them, so they're not able to have a conversation with you.
That's not true. I just feel like you guys don't have the patience to answer the questions or to try to understand the way that I ask the questions. to try to give me the answer that I can understand. That's it.
Well, I apologize you feel that way, but Ms. Rich has been on the phone with you many times, 15 minutes, 20 minutes, lengthy conversations, trying to extensively explain everything and answer all of your questions. I've heard her follow up with you. Do you have any additional questions? And you've concluded with no, you don't. So I assume at the end of all those phone conversations, she's resolved any questions that you had at that time.
So you guys don't have the time to, put up with me asking questions about me being concerned about me on probation, about the stuff that I don't understand? That
Again, I
that gets
think
on your nerves. I'm sorry. I
we've
apologize
resolved-
for that myself.
Go
I
ahead.
didn't know it was that serious.
Okay, well, let's do, hold on, that was a question, go ahead, answer it as best you can.
What was
Again,
it?
I feel like Ms. Rich has taken the time each time that you've called and attempted to resolve all your questions. And again, at the end of the conversations, she's confirmed with you that you don't have any additional conversations. Recently, she's advised you to communicate by email, which is
Right.
still not cutting off your communication. It's not cutting off you a method or a form to communicate or ask your questions. It's just a method to protect her and what she's actually said.
Protect her from what? What am I doing so bad to make y'all feel like I'm a threat when I talk or I'm asking questions? That's what I don't get.
Because you've told her a couple of times that she said something to you that was incorrect. You told her,
But I'm sorry. I'm sorry.
Go ahead, Director.
you've told her things that was not true. And so,
Which is,
like in reference to the community service, you stated that she didn't let you know that it was 139 hours, that the 70 hours would complete the whole conversion, that you were unaware that there was going to be additional hours that you were going to have to physically complete. So again,
that's correct.
Hold on, don't cut her off.
I'm sorry.
But there's an email that she sent to you back in April where she at first advised you of the incorrect amount of hours. She said a clarifying email, I believe it's sent on April 21st, clarifying the amount of hours. So you were not told up front the amount of hours that you would have to complete. Again, that was done by email. And I'm glad she did that because there's clear communication that she could present to the court that you were clearly advised of the hours you needed to complete.
Okay, Ms. Matthews, on the transcripts for the second opportunity, right? Those are, we're talking about hours, right? So the way that I was counting it wasn't correct. That's why I was calling, asking questions. I'm seeing like, it could be a course that might have took me like a whole day. So I'm thinking that one day, 24 hours, maybe like 30 minutes. I'm thinking that one day of me taking that course, that's 24 hours, but that's not 24 hours that you're pertaining to, right? So I didn't know how to calculate it.
You did not receive the documentation in the office of how each course was documented, how many hours were assessed for completing each section?
You're talking about the little script paper? Yeah, and I had a conversation with her because I didn't know how that was being counted.
So we provided you the documentation that said if you complete this course, it's worth 24 hours. If you do CRI, it's worth 7. If you do soft skills, it's worth 14. So we provided you documentation, a written document that provides you how those hours are assessed.
Right, and she broke it down to me as in a way that I still didn't understand. That's why I would call.
Is there a question?
No, ma'am.
Do you have any additional questions that you would like to ask the witness?
You're pertaining to Ms. Matthews?
No,
Sir?
I'm asking you if you have any additional questions.
Oh, no, sir, but I do have the paperwork for the community service that I was supposed to have completed.
Okay.
And it was only the job that I was having problems with here in Georgia by me leaving, going to different states with my background being ran, and it takes longer than usual. So I think I've came close to having a job soon here, probably by next week. They're just waiting on my drug test to come back.
Okay, let's pause right there, because again, we're still in the questioning
Okay,
this
no,
witness stage.
Yes, sir.
Now, you can give
Sorry,
whatever
Your Honor.
paperwork you want to the bailiff, that's fine.
Okay.
But either ask your next question.
No, sir, I have no question, Your
Have a
Honor.
seat, and like I said,
Okay.
you can hand the bailiff that paperwork. All right, Mr. Shepherd, call your next witness.
That's all the witness.
My 10 hours that I was supposed to have complete by this, 10th, but I took a job instead.
All right, Ms. Williams, the state has rested, which means they've provided me with all they're going to provide me
Right.
in this case, which means you have an opportunity at this moment, but not an obligation to present evidence in your defense. What that means for you is that you may choose to testify if you wish to, and if you will, I'll have you sit there, I'll have you pull the microphone up to you. Richie will help you with that, and I'll let you testify. If you choose to do that, Mr. Shepard will be cross-examining you, and you will be required to answer those questions. Do you understand that?
Yes, sir. Your
So,
Honor.
yes.
Can we just, I've done everything that I could possibly do on probation. I mean, like, I don't
Okay,
know.
well, only one of us is going to run this hearing.
Yes, sir.
And you trying to redirect this hearing
No,
is
sir.
not sitting well with me at all.
I'm sorry, Your Honor.
Sit down.
Okay.
Okay. I need you wanted this hearing.
Yes, sir.
And I am going to run this hearing the way the rules require me to run this hearing.
Yes, sir, Your Honor.
Okay, you have not been consistent in following my instructions. I have told you repeatedly, I had to tell you at least 3 or 4 times to ask Director Matthews questions. You talked to Miss Rich, and then you made a big, long statement to me. And I need you to understand that there are these rules in place of how things happen in a courtroom for a reason. They are here to protect you. And I'm going to do these rules whether you like them or not. And I need you to hear me understand that I am wearing thin with you going off in other directions other than where I'm telling you to go. Do you understand that this is me very much trying not to lose my temper with you?
Yes, sir.
Okay.
Sorry, Your Honor.
So you may make a statement from that seat. If you choose to do that, Mr. Shepard will cross-examine you, and as long as those questions are allowed by the rules of evidence, you will be required to answer them. If you choose to remain silent, I will not hold that silence against you because you do have a right to remain silent. Do you understand that you have a right to remain silent?
Yes, sir.
Do you have any questions about this moment and your decision of whether you wish to testify or remain silent that I can answer for you?
You answer for me, Your Honor.
Do you wish to testify or remain silent?
Remain silent.
Okay. Do you have any other witnesses you wish to call?
No, sir, Your Honor.
All right. That means that she's rested, which means there's no rebuttal, which means we're going to do closing, which means, Ms. Williams, Ms. Shepard, you want to go first, last, both?
I'll just go last.
Okay. Ms. Williams, if you want to kind of sum up this case for me and explain to me why I should not revoke your probation, this is your chance. And I will listen intently, as I've been doing, as to why you believe I should not revoke your probation. If you wish to not give a closing argument, you can do that. But this is your chance now to talk to me and to tell me why you think I should not revoke your probation.
Well, I've been trying, Your Honor. I've
Okay.
really been trying. I may have started out on the wrong foot with everyone. I apologize for that, Your Honor. But it's kind of hard returning back to a place where you left to do better and having to deal with something that's from the past. And the rules are now changed. Everything is different from the times that I was here in court. Your Honor, if you could have some type of sympathy for me to let me continue the rest of my probation out until tables turn for me, as in work. I will comply by not reaching out to the probation. Just contact them only by email if that's what they're wanting. I try not to have too many questions. If I have to do community service until I do get a job, I mean, I will. I just want to be able to make it 6 months here to finish it, complete it, and to get back on with my life. That's it, sir, Your Honor.
Okay. Thank you, Ms. Williams. All right, Mr. Shepard?
Judgment, the first case was closed unsuccessfully. She didn't pay off her fines. They worked with her when she was talking about moving to another state and actually waiving one of her fines. They've worked with her to convert her fines to community service. She hasn't done that. She's in arrears again. She's missed 2 out of 7 appointments. You see how she communicates with the probation officer. You see how she treats people. they shouldn't have to be dealing with that with Ms. Williams, and they have tried, you know how probation is, they bend over backwards with defendants, trying to get them to successfully complete their probation. All Ms. Williams has done is just been obstructive and rude to them. They shouldn't have to deal with it. Her underlying charges, these were both pretty bad reckless driving cases. They're all very dangerous behavior. I mean, I think enough's enough. I mean, they've been dealing with her for a year and a half. She just won't do what she's supposed to do. I think it's just time to revoke her in full.
All right. Any other housekeeping before I make my decision on this case?
None from the state.
Ms. Williams, anything else? All right. The evidence as I've heard it is as follows. She's on probation on the second of two consecutive cases, 22 SR 1538. This case, according to the testimony, has somewhere just under 200 days left. There was no recommendation, there was no consent order offered, and there was no recommendation from the state during the course of this case. Ms. Williams denied all allegations, which meant it became my responsibility to decide what to do on this case. The allegations were that she missed 2 out of 7 of her scheduled appointments, that she failed to pay her fines and fees as ordered, and that she failed to complete her converted community service work hours. I will say, of course, that on the second one, B, that the fees may always be waived upon proof of indigency and request. So with that said, those are 3 allegations. And my rule in this court is if you have 3 allegations, you go to jail. I am very surprised, Ms. Williams, that you're not in jail. Although I understand the sentence enforcement's team hope to work with you, I think you need to be in custody. So go ahead and put the cuffs on her, and then I'm gonna finish. And you can bring her up to the podium. All right. I also, during the course of this hearing, have been reviewing my docket, and I see that since 2000, you had 26 cases since 2000 with the Spalding County State Court, plus 1 or 2 felonies. I looked through those cases during the hearing, and they either all were closed with confinement or an unsuccessful probation. This last case, it was testified, the one before this one, which was 22 SR 1537, was also closed unsuccessfully, and this one's going to close unsuccessfully. During the course of this hearing, as I've already addressed with you, you did not follow my directions. You continually talked to people who are not on the witness stand, like addressing Ms. Rich directly when I asked you if you wanted to ask this witness questions. You continually went off topic and started making statements to me after I continually said, ask questions. I don't know what you were trying to do there right before you presented your case, where you wanted me to, I don't know what you wanted me to do. But either way, what that showed to me is when you're on your best behavior here and you're trying your best to follow my instructions, you were incapable of doing that, or you were just disregarding it. I'm going to go with incapable because I don't think there's malice in your heart. I just think you're not doing what you're supposed to be doing. As that said, I believe, unfortunately for sentence enforcement, this falls under no good deed goes unpunished. Instead of cutting you off several months ago and trying to avoid this, and frankly, having this moment several months ago, the sentence enforcement team worked very hard to try to save you, and it didn't work. And even coming here today, you did not acknowledge any responsibility for missing your appointments. You did not acknowledge any responsibility for getting behind on your fees or requesting it. You did not acknowledge any responsibility for it. I find that you are not a candidate for probation, to have no additional consecutive cases or anything else.
No, sir.
I'm revoking 197 days. Your probation is revoked. You may go with the deputies. You have 30 days from today if you wish to appeal this decision. You have 6 months if you want to use your habeas rights.
6 months in the county jail?
Yes, ma'am. Thank you. You may go. Richie, if she will sign this, great. If she won't, just write refused and bring it out for Carly to sign. All right, you may call your next case.
Judge, that's all that's on the probation calendar. You do have 2 more cases that are on the non-jury calendar that you may need me on.
Okay, we'll just sit tight then and let's pivot to the next one.
And if you want to see where Mr. Shepherd would like to go as well.
Yeah,
I'm fine
let's
with that.
say, Ms. Shepherd, you get to stay here, so.
It looks like you've got, it's the same two, Ms. Rideout and Mr. Watson. So whichever one you want to do.
I don't have a preference.
We can go, move this right out.
Okay, Ms. Rideout, if you'll come on up. Hi, Ms. Rideout, if you'll please raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, take your hand down. Please state your full name for me.
Carleen Rideout.
And Ms. Rideout, you're here today because you have requested a hearing before the court to modify your probation. Is that correct?
Yes.
Ms. Rideout, so that means, just to make certain we're all on the same page, you're not in trouble. There's no scenario where I revoke your probation. The goal is for you to make it better, and your worst-case scenario is I make no changes. Do you understand that?
Yes.
All right, so with that said, and you're welcome to stand or sit as you prefer. You don't need my permission if you want to sit down. Tell me, if I do what you want me to do, what would I do? So if you just could just tell me what you wanted and I do it, what would that be?
Terminate the probation.
Terminate the probation.
Yes.
Okay, perfect. You can grab a seat. All right, Director Matthews, talk to me a little bit about where we're at on this one and what the state's recommendation is, if there is one.
I haven't discussed it with Mr. Shepherd, but the court-ordered obligations are not completed. It's a 6-month no early termination case, 20 hours of community service. She has a stay away from the Griffin Spalding County school system at their discretion. She has 88 days remaining of the 6-month sentence, so she's about halfway through. She's currently in arrears $466. She has a balance of $586 remaining. She's made 2 payments on the case. The 20 hours of community service are completed.
Can somebody help me understand why we did 6 months on?
That's not, my handwriting is scratched out. And somebody wrote 6 over the top of it. That's not my writing.
It's not my writing.
I never do that.
I can tell you who did it.
Okay, fill us in.
Excuse me, the judge that was here before, that I saw originally. And
Beard, did he have a beard?
It's Tracy, Judge Howell's.
Oh, I didn't look at the bottom.
And Mr. Charles, they agreed to do instead of the 12 months, they agreed on that.
That's fine. When Trey was solicitor, they did 6 months a lot, so I could see.
I don't do 6 months.
I know you don't, but your former boss did. So, okay, Ms. Rideout, that makes sense. So I just couldn't figure out how I gave a 6-month sentence, because we do 12, but we'll let people terminate early a lot. But we just start at the top. So, okay, that makes sense that Judge Howell, who was a former solicitor here, who liked 6-month sentences, gave a 6-month sentence on the case. Okay, we're back to square one then. So, okay, anything else, Director Matthews? Do you want to?
I'll just say, I mean, she was, this was an incident that occurred at a school where her and some school employees got into it. She was charged with disorderly conduct in front of minors, in addition to simple assault on a school officer, also disrupting a public school. I mean, she ended up with what's apparently a 6-month sentence out of that. I mean, I think the intention would have been for it to terminate after 6 months. That is my handwriting there. So she's already got, I mean, she was looking at 36 months. And so she basically got 30 months shaved off what she was potentially looking at. She's got 3 months left. I think she needs to complete her sentence. I mean, she got a pretty good deal, and I did not know that until I printed this out a little earlier that it got reduced from 12 months to 6 months. And that's obviously what happened. We can't go back on it, but I think she needs to finish her 6 months.
How much time is left?
88 days.
Okay, thank you. All right, Ms. Rideout, anything else you want me to know?
Yes, Officer Matthews, that's incorrect. The school did send me an email giving me permission to come back on the property. I am allowed at the school. It was at their discretion. That was something that I suggested outside, when we were in court originally. And the school, when I sent that to them, told them everything was completed, they agreed that it was okay for me to come back on the premises. Also, I did not have a confrontation with the school officer, and I did not threaten anyone. The final charge was cursing in front of a minor. Everything else was dropped, It was just person in front of a minor is what I plead to. The issue with the probation is not the reporting, it's the money. It's hard for me to maintain a roof over the kid's head, pay for food and do all of that, and keep paying the money that I'm paying. I paid the $590, which was requested of me. Once I went to probation, it was explained to me that I have to pay an additional almost probably $600, and I just don't have it. I did have a second job, I had to let it go because having two teenagers and working more than 2 nights, some days out of the week, I'm sorry, because it just brings up emotions from the whole school thing. With my daughter being attacked and everything, but, I had to let the second job go
There's some
because,
tissues right there.
I'm fine,
Okay.
thank you. I had to let the second job go because the kids started acting out. They were having company in the house, doing things they weren't supposed to do, so I just can't financially afford it. The community service, I can do that and report, but I can't, the money I just can't do.
Okay. So you know you can convert your fines to community service work, and you're saying you don't have time to,
I know that now, after hearing what was said, I did not have a chance to speak to anyone at the probation officer to ask them, is there some way we can figure something out when it came to the money? I don't have a problem with reporting. I was transferred from coming in to being in person to over the phone. That's not a problem reporting. It's just the money, I can't do it.
okay. Okay. Anything else, ma'am?
No, that was it. Thank
Okay.
you.
Anything else, Ms. Shepherd?
No, sir.
Anything else? Okay. Ms. Rideout, as you heard just a moment ago, your sentence took Mr. Shepherd and I both aback. This sentence is much lighter than I would have given in this situation, and it's much lighter than Mr. Shepherd initially recommended. However, you did get the sentence. It was signed by Judge Howell in his capacity as stand-in judge, substitute judge, for lack of a better term. And I stand by it 100%. I'm just telling you on a personal level, the fact that this thing got dropped to 6 months is something you would have never gotten me to do on the bench. So the fact that you got it both dropped to 6 months and you're now wanting it to terminate early, and you haven't finished your obligations, if I understood the testimony correctly, is an easy no for me. You haven't finished your obligations. And this court has built itself on being, unless it's restitution, we are never a cash-only court. You can get your fees waived with indigency. You can move your fines to community service work. Like, we are one of the most flexible courts in the state of Georgia as far as this goes. How do I know that? Because I asked the other judges how they do it, and their other processes are much more intrusive and difficult than ours. And so I just need you to know that your statement that you were unaware of these options is meritless to me. And I just need to say that out loud, that your statements that you were unaware of your options is meritless. We do that in court all the time. So nothing personal, but the answer is a very easy no. You have 3 months left. You have not completed your obligations, and you need to go do those.
That's fine, I
Okay.
accept that. May I ask a question?
Yes, ma'am.
Okay, when you say the obligations, are you talking about what did I not complete? Because I paid the $590, which was extra paid upfront. I did have to break it into 2 payments due to finances. I did the 20 hours of community service, so I don't miss any reporting time. The only thing I have is the money to pay. So what did I not comply with? What did I not do?
All right, Director Matthews, do you know that offhand?
Yeah. You've only paid $514 as of today. We sent you those receipts yesterday, so you should have those for your records. You've paid $284 towards your $590 court fine, leaving you with a balance of $306. You currently owe 1 month of probation fees, and you have $100 due to the public defender's office for their service, and none of that's been paid.
And remember, all of those can either be paid or waived, but there is a process, and you have to engage in that process to get that resolved. So I'm going to leave you and the sentence enforcement team to work out those details. Okay?
I
All right.
accept that.
All
Thank
right.
you.
Thank you very much.
I
When's
can
her
leave.
next report date? Do you have it handy?
August 6th.
August 6th is your next report date.
Okay,
All right.
so I guess I'll reach out to Ms. Oliver before then to see about the
Sure.
fines.
Yeah,
Okay.
email's a great way to do that.
Okay, no problem.
All right, thank you, ma'am. Good luck to you.
Thank you.
All right, what was the last one?
Watson.
Watson, come on up. Okay. All right, you are Mr. Watson?
Yes, sir.
All right, and Mr. Watson, as I said earlier, you may stand or sit as you prefer. Mr. Watson, please raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, you're here because, you can take your hand down, you're here because you've requested me to change some of your probation terms. Is that correct?
Yes, sir.
All right, so you're not in trouble at all. Your best case scenario is I do what you want me to do. Your worst case scenario is you walk out of here exactly the way you started.
Yes, sir.
All right, so if I do what you want me to do, what would I do today?
I'm doing my community service through the data report. I'm going through passing all my drug tests. Only thing that is the family violence class. I'm on Social Security. I just can't afford the $45 per week. I'm on 24 months of probation. With this probation, I cannot afford the class and pay rent and pay Griffin Light Company.
So you're asking me to waive the Family Violence Intervention Program due to financial hardship?
I would like it. I could take anger management through the daily report because I do go to felony probation. But my
Wait,
probation.
the day report, you go into the day reporting center?
Yes, sir.
I'm an ag assault from January 6th of 2021, I believe.
Yes.
Okay, so you're going to both the day reporting center and doing the Family Violence Intervention Program?
Yes.
How much time do you have left on the day? I'm just exploring this to make certain
Daily
I've got it.
report.
Yeah, how much longer do you have on that program?
I'm in the second phase, so I got about November. I'm on the second phase. After I do this, after I get out the aftercare, they will terminate the rest of my probation. I'm going through the classes, fail no drug tests. I'm doing the community service down there, so.
And how much time does he have left on probation? Do you know?
He has a consecutive case that hasn't started, and then on the current case, it just started. He has 223 days remaining as of today.
Okay, all right, I cut you off, but I'm tracking what you're asking. And anything else that you're looking for from me today?
I don't mind doing the family violence. Can we just change it to assault? Well, they were in the daily report. They have a class that I'm already taking
For family violence?
So it's not family violence. I think it's assault or aggravated assault charges.
Okay.
Yeah, I just want to commute that.
Okay.
Besides paying because I can't pay the rent, and I don't mind paying my rent. It's just the Griffin Light Company is killing me.
Yes, okay, I'm tracking you.
Yeah.
And I pay Griffin Utilities as well, so we get it. Okay, well, let's do this. Tell me a little bit.
Okay.
No, all I was doing at that point, everybody, was clarifying what he wanted. Just to be very clear that everybody always gets nervous when I do that, but I'm just trying to understand what his world looks like. Now we're just going to pivot to where we normally were. Tell me what's going on.
Okay, so he is on felony probation, 21R 297. It's a 10-year sentence. We've communicated with his felony officer, Officer Leverett, and for that felony case, he has to complete family violence on that case also. So, and they're not waiving it. The only thing they're doing is once he completes the DRC, then they're going to require him to begin the family violence classes. So they're not going away for him to finish felony probation.
Well, you should know that's all I was thinking of. I was just kicking around the idea of moving our family violence requirement to the end, but I didn't know we got a consecutive case. Just letting y'all know that was as far as I had thought into it, so.
Yeah, I mean, if we wanted to move it to the second case, to allow. Yes. Mm-hmm. To allow him to have time on it, but as far as I understand, he has multiple victims between the cases, so I wouldn't recommend that the court remove the family violence.
Okay, and I did not have any intention of removing it. I was just trying to get an idea of structuring it. Are y'all okay with that? of moving the family violence to after the completion of the day report center.
How long has he got left on that?
I mean, by his testimony, he's gonna be in phase 3 in November and then aftercare. As far as I know, we don't have an estimated date of when the DRC would be completed. My concern is having a 10-year sentence. I mean, they have a lot more time to
Yeah.
work with him
Oh, they sure
than
do.
the 2 years that we have. I mean, I would say within 180 days of the affray starting, that it would need to be completed.
I can live with that. It'd be a condition of his second case to be completed within 180. Does the second case have an early termination on it?
No.
And could I add that he must complete the day reporting center? Because that's what would show why, like 5 years from now, when none of us remember this, that would show why we moved it. I added the day reporting center, moved the family violence into the second case.
Yes, I
Okay.
agree with that, because I mean,
I
we
don't-
don't know when that's gonna happen.
All right, so what we're exploring, oh, go ahead.
I don't mind taking the course, I just can't afford it. I know I got a problem
Well,
with it.
felony's gonna require you to do it either way.
Yes.
And we're not doing it twice. You're gonna do it one time for both probations.
Okay,
But felony's gonna make you do it no matter what, and so
Yes.
I'm not gonna waive it.
all right,
But what I'm thinking about doing is, with your permission, modifying both of your cases.
okay.
So I'm moving the family violence intervention program to your second case, which should let you finish your day reporting center obligations. And,
Can you help me with the fee?
so I cannot, but we can certainly discuss that then. But remember, felony's not moving it. So even if I were to say, I'm closing your probation and you're totally free, go and live well, like, it wouldn't change your world. You still have to do the family violence intervention program for your felony probation, and they're not waiving it. So
But
that's,
they have a course and they program, but
but the family violence intervention program is part of your felony probation.
yes, but
Yeah.
they have a course down there. But this probation here don't have it. I have to take the class outside, and I don't have to pay for it. That's the only.
Yeah.
I don't have a problem with paying. I don't have a problem with going to the class. It's just my problem is I don't have the funds.
All right.
Because I receive Social Security, my check is so much, my rent is so much.
All right, we will circle back to that if and when we need to,
Yes, sir.
when we get to your second case.
All right.
So right now, this is all I'm willing to do. I'm willing to move it to your second case. I'm going to add the day reporting center with your permission.
Yes, sir.
And that way it'll be clear as to why I did it. And then obviously, if we need to talk finances when we get there, we can have that conversation.
Okay.
You'll do what you did, come back here and talk to me. I don't know what I'll do, but we can have the conversation, and that's okay.
Okay.
All right, any questions?
No, sir.
All right, so they'll send me an order in a little while. I'll sign it and file it, and you'll get a copy next time you report.
Okay.
All right, good luck to you. I hope this gives you just enough room to let you get through this successfully.
Yes, sir.
Thank you, sir. Okay. Issue the warrants, forfeit the cash bonds. Anything else? Y'all, y'all had me really worried about today, but it's 12:01. Y'all did a great job. So, all right.
Y'all moved it good.
Court's adjourned until, I don't even know, till court starts back up.